welcome to this CCTL seminar. It's my pleasure to welcome the speaker, Szilárd Gáspár Szilágyi. Dr. Szilágyi is a lecturer in EU and International Economic Law at Birmingham University in the UK. He's previously worked at Kiel University, at the Pluricourt Center of Excellence at the University of Oslo, at the University of Amsterdam, and at the Hague University of Applied Sciences. He studied in Romania, the Netherlands, and Denmark, and conducted research across many continents. He regularly publishes on topics concerning international investment law, EU external relations, and regional economic integration. Today, Dr. Szilágyi will be speaking to us on with a presentation called The Palm Oil Wars and the EU's Common Commercial Policy. And really, as I understand it, it's going to be as a way to illustrate how legitimate non-trade EU concerns are creating issues with trade policy and the formulation of trade agreements. I look forward really to hearing actually about this fascinating topic and Dr. Szilárdy's views. He'll speak for approximately 30 minutes, and then we should have ample time remaining for question and answers. I will say at this moment, please use the chat function to send through any and all questions you have. You can do that, of course, while Dr. Szilárdy is speaking. I will collate the questions and ask him directly the questions after the presentation concludes. I will now go back to the topic at hand and invite everyone to join me in virtually welcoming the speaker, Dr. Szilárdy. So the floor is yours.
Thank you very much, Brian, for the invitation, and thank you very much, Fernando, as well. I had the pleasure of meeting Fernando in 2015 in Santander. We were at a conference, and then there was a time, I think roughly until 2017-18, when almost every year, 3-4 times, we would bump into each other at various conferences. So thank you very much for the invitation, also for the Chinese University of Hong Kong. I had the pleasure of being in Hong Kong in 2017. Back then it was a conference organized by Professor Shez on EU and China investment relations. So it is really a pleasure to be here. Now today, and I will share my screen a bit with you. So I have a couple of slides just to make the talk a bit more interesting. I will be talking about the so-called palm oil wars and the EU's common commercial policy. And as Brian said, the purpose of the lecture is a bit to put the EU's common commercial policy in a broader context, internationally, but also of non-trade values. So the purpose of the lecture is to showcase a bit how these non-trade values are affecting the EU's common commercial policy, which I name in the paper as an inflated common commercial policy. Now, the paper I've sent you before, for those of you who had the time to look at it, was accepted very recently by the European Foreign Affairs Review. And of course, as it has it, the reviewers had quite a lot of comments as well. So I'm working through the comments of the reviewers. So maybe some of the arguments I'm presenting today might not be exactly the same as in the paper. Now, of course, I also have to say a little caveat that one of the reviewers was probably not very happy with, as you will see, with how I ranked the various non-trade values. So he was not very happy that I put environment as sort of an intermediate level non-trade value, not as a high level non-trade value, but I somehow have to address his comments as well of the reviewer. So that being said, let's look a bit at what am I going to be talking about today. So I want to discuss a bit first two contexts. So what is the EU's inflated common commercial policy? What exactly do I mean by the inflated common commercial policy? And then a bit, I would like to talk about the so-called palm oil wars, which are ongoing now between the EU, Malaysia, and Indonesia. And then from these two contexts, we will have an analytical part where I will look a bit at all the different issues that this inflated common commercial policy is causing, all the different actors that are being involved, in order to draw some preliminary remarks. And based on those remarks, I will look a bit at my sort of normative assessment of the situation and my proposals of when the EU should have a more concessionary approach based on certain trade-offs with its contracting partners, and when should it follow a more principled approach. Now, some of you might be more aware of how the EU functions, some of you might not. It's always one of these very interesting topics where you go to a conference and if you have a panel, if it's an international conference, and if you have a panel with EU lawyers, it's one of those panels where you should first have a script in advance just to make sure that you understand all the terminology and all the inner intricacies of the EU. And then there will always be a question followed raised by someone in the audience who will ask, well, I thought you've already solved this issue in XYZ treaty amendment. And then we all look at the person in question and we just have to give a very honest answer of, no, we have not solved the issue, and actually it's getting more complicated. So that's a bit my idea about how the post-Lisbon common commercial policy functions. I think it has become a bit too big. It wants to achieve too many things in the same policy area. And because of that, as we shall see, it is causing friction with other contracting parties. Negotiations tend to be very lengthy lately. There are a ton of issues, both internal and external. So I think the common commercial policy should get a bit of a brush up. So let's look at this common commercial policy. Now, the common commercial policy par excellence is one of the few actually policy areas which are under exclusive EU competence. So other areas would be the monetary policy for countries that have the euro, or for example, customs unions, and for whatever reason, the protection of marine biological resources. It's always one of those things that the students and also the practitioners forget about. Now, the CCP has gone through a number of changes over the years. As you know, the EU is founded on basically the Treaty on the European Union and the Treaty on the Functioning of the European Union. These are the new names after the Lisbon Treaty. However, there were successive treaty amendments and new treaties over the last 70 years of the existence of the EU and the previous of the European communities. And the Lisbon Treaty has brought quite a lot of changes, especially to the common commercial policy, which is now, a lot of these changes can be seen in Article 207 of the TFEU. And I would probably group the changes, I call it in the revised version of the paper, as the three-legged changes, because there are three major legs, I would say, to the CCP changes, all of which are important for today's conversation. So the first leg, and I will mark it in red here on this slide, is an expansion in scope of the CCP. So we have seen that originally the CCP was a more narrow area of policy that concerned the conclusion of tariff and trade agreements, initially in goods, then it was also expanded into other areas such as services. And now we see an expansion into the commercial aspects of intellectual property. And very importantly, one of my favorite topics is an expansion into foreign direct investment. And these three little words, FDI, that's why I even put in brackets, oh boy, did they cause a lot of headache in the last decade. Like really these three tiny words, this expansion into a new field of the CCP has caused really a lot of headache, especially internally, but also externally, and I will touch upon it a bit as we go further. So we have this first leg of expansion into new policy fields, most importantly, FDI. But also something quite interesting happened was that now all types of EU external policy actions, so not only in trade, but other external policy fields as well, they all have to follow various values, and these are non-trade values of the European Union. Now, this is not a novelty. So even prior to the Lisbon Amendments in 2009, there were cases in which, quite a lot of cases, where you would have an EU trade agreement or an EU association agreement or an EU partnership agreement with other countries, and they would have various clauses, for example, on the protection of human rights or some labor clauses and so on. But we didn't have a legal obligation to do this. But now there is a legal obligation. So more or less in Articles 2, 3, and 21 of the Treaty on the European Union, now contain these non-trade values, which the EU will have to uphold and promote in its external relations. So that is a bit that is a very important new development, because it puts a constitutional constraint on the EU negotiators. So even let's say we have a negotiation with a partner country, and the EU negotiator might say, well, let's just focus on trade. That will not entirely be possible, because there is now a constitutional obligation that in its external fields, the EU has to uphold its values and also promote various other values. So that's the second leg of the changes in the CCP. And the third leg is that the European Parliament, which is the only democratically directly elected body of the European Union, now has an increased role in the common commercial policy. So internal implementing measures, it will have to lay down together with the Council. And when it comes to the conclusion of international agreements, not only does the Parliament has to be fully informed throughout the process of negotiations and the conclusion, but now it also has a veto power. So if the Parliament doesn't like something, it can draw the attention of the EU negotiator and say, you have to be very careful, because at the end of the day, I will simply not give my consent to the agreement. And this has happened before with some of the data privacy agreements with the United States. So we do see an expansion of the CCP. We see that it has expanded into new fields. And then we have this constitutional obligation now to promote various non-trade values. And we also have the European Parliament as a very important actor, having a very important role in the process of concluding trade agreements. So this is what I call sort of the inflation of the common commercial policy. And I derived this term from this article from 2010 of Horn and Mavroidis, in which they spoke about the legal inflation of US and EU preferential trade agreements. I don't focus on the legal enforceability that much. I'm more interested in the negotiation and how these changes affect the negotiation, but I would call it an inflation, right? So traditionally, a trade policy of a country tends to focus on trade. They tend to be removed from other policy areas, however, not in the case of the European Union. So just to give you an example of what this so-called inflated CCP can result in, this is a sort of a skeleton version of CETA. So this is the sort of golden standard, new type of EU preferential trade agreement with Canada. And as you can see, the areas marked in black, they tend to be more traditional, old school trade agreement type of field. So you will have market access for goods, trade remedies, technical barriers to trade, and so on. But of course, we have a lot of new additions as well. So we have investment. Now, for some agreements like the EU-Singapore agreement or the EU-Vietnam agreement following Opinion 215, we had a split. So CETA still has investment in the agreement, but some of the other agreements now have investment as a separate agreement to the trade agreement. We see intellectual property, we see sustainable development and other competition related issues, such as, for example, in a lot of these chapters, you will have references to environmental standards, level playing field, ensuring some minimum labor standards, and so on. So we do see quite a hefty expansion, not only of the CCP, but then this influences the content of these preferential trade agreements. And because now there are more and more things included in the preferential trade agreements, it also means that there are a lot more issues being drawn into the trade policy and a lot more actors. And if you have more issues and more actors, you will have obviously a bit more of a complicated policy field. And it sure is complicated lately. So that is the CCP. So just to recap, we have the Lisbon Amendments. They bring in three important changes. So the first leg of the change was an expansion in scope of the CCP into new areas such as the protection of foreign direct investments. We have a second change. Now the EU is under a constitutional obligation to promote certain non-trade values in its external policy fields. And we also have the increased role of the European Parliament. So that is one context. Now, the second context refers to the so-called palm oil wars, which are now unfolding between the EU, Malaysia, and Indonesia. Now, of course, academics would like to be dramatic and call wars. These are trade wars. Luckily, no one is getting hurt. Probably, unfortunately, some orangutans maybe on the islands of Borneo and Sumatra, but luckily no human beings are getting hurt. So what exactly is palm oil? Now, some of you might know, some of you might heard of it. Palm oil is a commodity, and I put three different pictures here because these are all sort of like three aspects of palm oil. So on the one hand, you have these plantations, and that really is the thorny issue with palm oil, because, for example, in a country like Indonesia, which is one of the biggest producers of palm oil on the planet, you have a lot of deforestation of the rainforests in order to make way to these palm oil plantations. Now, because of this, not only, this is very detrimental to certain endangered species like the orangutan, it also causes environmental degradation. But on the other hand, someone who does trade law, I also have to look at the flip side of the coin. And some of the studies I've looked at, they do show that roughly 2.5 million farmers, subsistence farmers, do rely on this crop because it's a very important crop. It has a high yield. So, for example, compared to other oil crops like sunflower or rapeseed oil, they tend to have a yield per hectare which is almost 5 times more. So it's it's a very economically beneficial crop to have. It originates from West Africa. Then during the colonial period, it was brought to other parts of the globe, especially Southeast Asia as well, and Malaysia and Indonesia. There are the two world biggest producers. Now, palm oil is a commodity. It's also one of those super crops which has a very varied use. So I put 3 pictures here. On the first one, you can see that you can use it as cooking oil, so you can just use it simply in the kitchen. But it's also, and this is the main issue here between the EU and Indonesia and Malaysia, it can be used as biofuel, so as an alternative to regular fossil-based fuel. And it really is used very heavily in the food industry. So pretty much if you have processed food in your fridge and you were to look at the ingredients, some of them, or roughly half of them, will include palm oil. So a friend of mine, for example, who's a big fan of Nutella, I had to remind him that he should read the label of Nutella because roughly half of Nutella is palm oil. So the old ingredients of the Italian gentleman who invented Nutella, of having, hazelnut cream and paste mixed together with chocolate and milk, that is more or less palm oil with some other ingredients as well. So the ingredients. Now, why is palm oil, an issue, a bone of contention between the EU and Indonesia and Malaysia? Well, the EU has adopted certain internal legislative measures. I don't want to bore you with, with these long numbers of the directives, but this first directive from 2009 basically set out a an EU-wide renewable energy target for the future, and then they break it down into national targets. So this means that by a certain year, a certain amount of your energy has to come from renewable resources. And in these renewable resources, they also included biomass. So in 2009, this biomass would also include, for example, palm oil. So you could produce palm oil in Indonesia, you could sell it to, for example, processor in the Netherlands, and then they could convert it into biofuel, or you could simply import the biofuel straight away from Indonesia if it was already processed. Now, by 2015, things started changing, and these have to do with some of the definitions that changed. So we have this new directive from 2015, which changed some of the definitions of the 2009 directive. So now certain biological products or waste products could not be used as biomass. And this affected palm oil because basically the directive said that if the sole purpose of this biological based fuel was to make it into fuel, then it cannot count as waste, therefore it cannot be biomass. So normally, if, for example, you have a main activity and as a result, you have some biological waste, you can use that as biofuel, but you could not use it if the sole purpose was to make it into this. So this started affecting palm oil exports from Indonesia and Malaysia. And then we have a new directive from 2018. It really just entered into force in June. This is the recast directive, so it repeals the previous two. And basically it keeps these original definitions, and it also includes delegated regulations. Delegated regulations, they're just adopted by the Commission separately. So, they're based on an underlying legislative act. So we have the Father Act here, or the Parent Act, the recast directive, and then we have this delegated regulation adopted by the European Commission, where the Commission has all these very technical tables on how you count, for example, something as being a source of renewable energy and not. And they use a coefficient, basically how much land is being used for other purposes. So this includes like wetlands or rainforests. So if you are converting a wetland or a rainforest into making biofuel crops, then you will have a very negative coefficient, basically meaning that some of these products will not be able to qualify in this renewable energy scheme. So that's important to remind, the readers and people who are interested in this, in this ongoing trade war, is that the palm oil export into the EU is not banned per se. So it's not prohibited, you can still do it. However, what did change, as I've just mentioned, was whether or not palm oil can count as a source of renewable energy. So because now palm oil can't really be used as a source of renewable energy, the demand for palm oil will fall, because more than half of the palm oil was actually used for biofuel. And this is, of course, what upset Indonesia and Malaysia, because now all of a sudden their exports to the EU are affected. So what did this cause? Well, I'll be mainly focusing on Indonesia now, because I think they have the more interesting case. So the countries retaliate. The negotiation of the preferential trade agreements are put on hold. Malaysia already put on hold the negotiations, I think 7-8 years ago. Indonesia now is in the process. I think they just concluded 7 or 8 rounds of negotiations, but right now they're stalling. And we started having trade retaliatory measures. So given these internal EU measures, the Indonesians decided to de facto ban the import of alcoholic beverages from the EU in 2019. This caused, of course, retaliation from the EU. We imposed provisional countervailing measures on Indonesian biodiesel. Then this caused further retaliation from Indonesia, where the government was requested Indonesian importers not to bring in EU dairy products. So this is unfortunately the problem with trade wars. You start banning something, someone else retaliates, and then it becomes this game of retaliation. And in 2020, first Indonesia and then Malaysia as well, they started bringing panel proceedings before the WTO panels. And they are alleging that the MFN treatment clause, the national treatment clause, and the prohibition of quantitative restrictions of the GATT are being infringed by the EU. And in 2021, the EU High Representative for Foreign Policy and Security Affairs met in Jakarta with Indonesian and ASEAN leaders as well. He's trying to sort of smooth a bit the current situation. The issue, of course, is that the High Representative for Foreign Affairs is for foreign affairs and foreign policy and security, not necessarily for trade. So it should be the European Commission which steps up in this case, because they're the ones who have to represent the EU when it comes to trade-related issues. So those are roughly the two contexts, right? So on the one hand, we have this common commercial policy, which has definitely expanded in scope. We have a new important player, the European Parliament, and we have all these important non-trade values that the EU must now uphold, support, and promote on the international scene, some of them being sustainable development, environmental protection, the eradication of poverty, but also higher level values such as protection of human rights, democracy, rule of law, and so on. So that's one part. And then we see this other part where we have internal EU legislation meant to protect the environment and to increase sustainable development, which of course affects the exports of other trading partners, and they retaliate, and then we start having this trade war between the two parties, which affect the ongoing negotiations. So this have a very clear effect on the common commercial policy, because right now the negotiations are either stalling, or in the case of Malaysia, the negotiations for a PTA are suspended. So because of this inflated common commercial policy, and because of this, having this EU internal measures with external ramifications, we end up in a very tangled situation. And I know it's 5 p.m. in Hong Kong, so I hope you will bear with me. I have a little chart here. I'm very proud of having made this chart. You will see, I will fill the chart. So this is sort of a mapping exercise just to see how complicated the negotiations of EU preferential trade agreement are currently. So on the one hand, we have the two parties, right? Let's say the EU and Indonesia, the other contracting party, and then there's a big question mark. Will there be an agreement? Will there be a handshake? So we have multiple interests on both sides, because on the EU, on the one hand, well, we have the European Commission, they're the ones who are the negotiators. But even in the European Commission, we will have, of course, multiple directorate generals, so DGs. So we have DG Trade, they're the ones who are in charge of the common commercial policy, but we also have DG Environment, they're the ones who are in charge, for example, of this type of renewable energy legislation. So then the question is, is the Commission internally coordinating enough? Because if you have internal legislation that affects external negotiations, then it might mean that there's not sufficient coordination within the Commission. But we also have the High Representative, who is held by the European External Action Service, is sort of like the foreign ministry of the EU. And normally their competence is everything but trade, because it's the Commission that handles trade. But now we've seen it in 2021 that it's the current High Representative of the EU having to go to Jakarta and trying to understand what exactly is happening with this negotiation. So there's definitely, in my opinion, a need of coordination and consistency on the EU side, because of course it is also a question of credibility. It's not a very nice image that the EU portrays to contracting parties if they cannot have a unified voice. But then, of course, we have a new actor in the common commercial policy, the European Parliament, and the European Parliament right now is very adamant about protecting the rainforests, and they have several resolutions condemning palm oil being used as biofuel. So with the threat of a veto, they can pretty much tell the Commission, look, unless you have some type of provisions in this trade agreement on palm oil or sustainable development, we're not going to agree to the agreement. So now we have the EP. But we also have the Court of Justice. Why? Because we've seen that as the common commercial policy expanded into new fields such as foreign direct investment, all sorts of issues popped up, mainly internal issues about whether or not investor-state dispute settlement is compatible with the EU legal order's autonomy. How should one delimit the competences for trade agreements between the member state and the EU? So we have the CGU coming in as an important player. Then we have NGOs, and there are a lot of NGOs in Brussels that do exert indirect pressure on the EU institutions. But then, as we've seen in the last decade, the member states are becoming more and more vocal. So for example, Austria said they will veto in the council the EU-Mercosur agreement if Brazil doesn't make credible commitments protecting the rainforest. And then in the case of investment law and EU's investment court system, we've also seen member state sub-federal entities such as Wallonia. Like, who heard of Wallonia until 2017? Unless you're a big fan of Belgium, a lot of people have not heard of Wallonia. But then the Wallonian government did not want to agree to the conclusion of CETA unless they got an opinion from the Court of Justice that the CETA investment court system was compatible with EU law. And also on the member state level, especially in Germany, we have very influential and powerful NGOs as well. So as you can see, just looking at the EU side, this is not an easy web of issues and actors. So as the common commercial policy has expanded, we see new actors coming in, influential actors. We see a bit of lack of consistency and coordination between internally the EU institutions, but also externally. So what should the HR do and what should the Commission do externally to represent the EU? We also see the court stepping in as an arbiter to solve some of the internal conflicts. And we also see member states and civil society becoming more and more vocal. And you would say, well, fine, but at the end of the day, the EU has to speak with a unified voice. But we also have the contracting party. We cannot neglect the contracting party. So here, we can argue, and I have argued this before in a previous paper on the EU's investment policy, that it really depends who you're dealing with, right? So in a simple model, if you're dealing with a strong party like the US or Japan, then it's a bit more hard to compromise. So either the agreement doesn't come to life, like in the case of TTIP, TTIP is dead, or you can have the agreement with Japan, which is sort of a success story. But in the case of Japan, the EU was willing to remove the investment court system on the insistence of Japan. And then sort of the standard model would say, well, if you're dealing with a weaker party, like let's say Canada or Singapore or Vietnam, the EU can simply impose the agreement. And we've seen this, the US doing it in its own agreements as well. This is the model agreement, take it or leave it, we're the strong party. However, that model doesn't seem to apply to Indonesia and Malaysia, and I have two reasons for this. One, it's hard to compromise even with a weaker party if their vital trade interests are affected. And in the case of Indonesia, for example, something like 15% of their exports are palm oil. So of course, it is a vital interest for them, and they might be willing to reassess whether or not they want to have an agreement with the EU. And also, and this is, I think, sometimes the EU trade policy should have a bit more of a foreign policy and foreign security element to it. You have to see also who are the neighboring regional and global powers, right? So in this case, we have China and then we have India. And a lot of the palm oil exports, they are going to China and they are going to India. And from 2017 to 2019-20, the level of exports of palm oil to the EU have fallen, but they have increased towards India and China. So, if you have a weaker party, but they have suitable alternatives in their own region where they can then redirect their exports, well, then it's fine. So, this is, as you can see, a very simplified version of a very complicated situation the EU finds itself. So it has this inflated common commercial policy. It has this constitutional mandate to pursue certain non-trade values, but this on the EU side creates all these issues and brings in all these different actors, but also for the contracting party, it creates issues. And this model of, I'm the strong party, I will impose my rules on you, doesn't seem to function in case you have even a weaker party who has a suitable alternative or some of their vital interests might be affected. So here are some of my preliminary remarks. So we can see that internal EU measures in one policy field in the environment can have very detrimental effects on, for example, other policy areas of the EU, in this case, the trade policy. Unfortunately, there seems to be a lack of coordination and consistency on the EU side, which does affect the EU's credibility. Now, one of my reviewers was not very happy about me saying this. He said, what's the evidence of it? I was like, go talk to the EU's partners. So I remember during this 2017 conference in Hong Kong, at that point, we had opinion 215 unfolding, and this concerned the competencies regarding the EU-Singapore agreement. And I spoke to one of the trade representatives of Singapore, and I said, "Madam, what do you think of this? I mean, you as the contracting party, how do you view the EU's actions?" Because they were constantly going back to the negotiating tables. And she just, shrugged her shoulders and said, "Well, what are you going to do? It's the EU. We just have to wait and see until they figure it out." So, of course, that is not a very nice way of marketing ourselves, especially in a new world where the EU's share of the global economy is falling. Also, as I've just shown in the case of Indonesia and Malaysia, just because you are dealing with a weaker party doesn't necessarily mean you can impose your norms if there are vital trade interests involved or there are suitable alternatives. And I think the EU really needs to step up its game a bit in the trade policy field, be a bit better aware of what are the regional powers in a certain area. And given all of this, we have seen that EU trade agreements are becoming increasingly more difficult to negotiate. CETA took 9 years to negotiate, and it's still not fully ratified because there's still some member states which haven't ratified CETA. It's a mixed agreement, so the member states have to ratify it as well. EU-Singapore dragged out way too long as well. So, it's sort of, on the one hand, the learning process, but also it's a frustrating process for the international partners. So then, what should we do? How should we move forward? We have this inflated EU common commercial policy. We have all these non-trade values included into it. So basically what I argue is, and in the new version of the paper, I will not use the word hierarchy, I will use the word prioritization, to give priority to certain values over others in the external policies of the EU. This is because EU lawyers don't like the word hierarchy because it has a very legal meaning, and I don't want to make it too legalistic, so I'm going to go with the concept of priority. So I basically argue that the EU should have some form of ranking of its non-trade values. So let's see a bit what these non-trade values are. As you can see very early on, Article 2, so it's almost the first article of the Treaty on the European Union. It tells us that the Union is founded on certain values. So these are respect for human rights, dignity, freedom, democracy, equality, rule of law. So I would call these the foundational values. And then we also have Article 21, which tells us that the EU's external action shall be guided by these values. But then we have Article 3.5 TEU. So in its relations with the wider world, the Union shall uphold and promote its own values. So democracy, human rights, rule of law, these foundational values. But then we have a more, I would say, aspirational provision where it says that the EU shall contribute to peace, security, sustainable development, solidarity, and so on. So I argue that there's some textual evidence here. I mean, EU lawyers don't like textual interpretation because the CJU tends to be very purposive in its interpretation. I'm more of a textualist myself. I argue that there is some evidence here in the text that there are some values which have to be upheld and promoted. So that's more, that's a stricter obligation. Upholding is almost an obligation of result. So this would be human rights, rule of law, democracy. And then we have sort of intermediate level values, which are more aspirational in nature. So these are more obligations of conduct instead of obligations of result, where the EU has to foster sustainable development, environmental protection, and so on. So I basically end up ranking these non-trade values that the EU has to pursue in its common commercial policy into three groups. So there are higher values. As I said, these are the foundational values, such as, let's say, human rights, democratic values, and so on. Then medium values, such as sustainable development, environmental protection, eradication of poverty. And then lower values, such as investment protection and ISDS. Now, I'm a fan of investment law. You might ask me, why would I put investment protection and ISDS as a lower value? Two arguments. One is the textual one. So it's only FDI, so foreign direct investment, which is mentioned in the common commercial policy. as a new field in which the CCP has gotten into, but it's not mentioned anywhere either in Articles 2, 3, or 21 TEU as a value. So there's no real, textual underpinning to have it in the same category as high or medium level values. But also we've seen that it's one of those, aspects that can be easily removed from a trade agreement if it can compromise the conclusion of the trade agreement. So after opinion 215, the EU chopped its agreement into two. So you can have a separate trade agreement. Let's move on with trade, and then let's figure out the investment agreement on the side. And with Japan, I know this from internal sources from the Commission. Japan was very clear in the negotiations. They said, we don't want this investment court system, take it out. And the EU said, well, okay, we'll take it. So there's practice for investment being taken out if it compromises trade negotiations. And there's also no textual basis for having investment at the same level as other non-trade values. So what I argue is that if we have high level values, and my apologies because it seems to me that they've decided to trim the hedges now. British people really love trimming the hedges every 3 days or so. It's a lot of rain, so it grows a lot here. So if we have high level values, then I would say the EU should go with a more principled approach, meaning if there are no credible commitments from the other contracting party that these values can be protected, then if push comes to shove, the agreement should not move forward. Why? Because there is this, constitutional obligation to uphold and promote these values. For medium level values like sustainable development, environmental protection, eradication of poverty, I argue that here the EU should have a more concessionary approach. It should accept certain trade-offs. It should be willing to listen more to the contracting party and to compromise more. Because, I would say that probably Indonesians living in Indonesia, knowing the situation, have to be listened to if we are deciding on measures that can affect our relationship and our trade with the Indonesians, right? So one should not have a bit of this arrogant approach of we know how to best deal with the protection of the rainforest, but you have to sit down, you have to compromise more. Also because I think in my honest opinion, even though the environment has to be protected, you cannot have absolute levels of protection, right? So you have competing interests here. On the one hand, you want to eradicate poverty, but 2.5 million people rely on palm oil plantations. So what do you do with those people? It's not such an easy, situation to solve. And if I were to be very cynical, if we really want to protect Earth, then let's hope Elon Musk can terraform Mars, and then we can just go to Mars instead of living on Earth, because any type of human activity will affect it. And then, with lower values such as investment protection and ISDS, we already have a practice of removing them from either completely from the trade negotiations, like in the case of Japan, or simply splitting the agreements into two. So that wraps up my presentation. Now, I know it's 5 p.m., actually past 5 p.m. in Hong Kong. It's a Monday. As we say, not even the grass grows on a Monday, but apparently it grows here in the UK because they are trimming it. But with this article, I wanted to give you sort of an overview of how complicated the EU's common commercial policy is, how many different actors we have, how many different interests we have. I'm possibly more of a realpolitik type of person. It's very important to have principles, but also the EU has to be more aware of its own presence in the international stage. It's shrinking, economic percentage as well, if we look at the global economy. And for certain values, it should have a more compromisable approach, in my opinion. So with that, I would like to thank you very much. And now I will stop sharing the slides.
Great, thank you, Szilárd. That was an excellent presentation. I think well-paced and very informative, quite fascinating. I mean, you brought up a number of points which are interesting to me as a trade lawyer as well. And in in relation to the palm oil, this long-standing controversy, I guess, between a product and the process by which it's manufactured. And so, would like you maybe to speak a little bit in a minute about maybe that potential, those claims that are being made by Indonesia and Malaysia. Is an oil and oil and oil, or is there something different? I also thought it was quite fascinating, your slide on the overlapping mandate. I also would have been very proud of that slide, so you have reason to be. On the overlapping mandate and the lack of coordination, I can assure you that is not only an EU problem of, say, trade, environment, intellectual property, now some digital departments not speaking to each other. But I think what you did was point out that the EU has multiple layers and that extend beyond even a federated country or a decentralized country. I have for years, actually, I have to say, said that the EU was not a reliable or credible negotiating partner. Most Europeans will, bite my head off when I say that. So I appreciate that you also said it. I think there's a real gap there, and something needs to be done. And I keep being reassured by people, no, it won't happen again. Something has changed and it won't happen again. And then it happens again. And so I think this is a problem that the EU will have to address. There's been a few questions. I've kind of asked one. I'll ask another one now, and then after you answer, then I'll come back and ask some more, both from the floor and my own. The one question, I think you really hit on this point quite a lot, but maybe flesh it out with a little more detail, was how successful has the EU been in convincing FTA partners to include these provisions? And also, I think the question hit on more broadly sustainable development measures. You might also want to, I'm just adding, make reference, of course, the CAI, the not so comprehensive agreement on investment with China did in fact include a measure. So that question, I guess you can address, as well as my previous question about trade and the product-process divide.
Thank you. Those are all great questions. So I also teach WTO law. I'm not that much into the product and processing methods and how that might affect, for example, whether we can consider a like product like. I know that in this case, one of the arguments, of course, would be also indirect discrimination on the side of the EU. And of course, if you take a skeptical view, you could argue that the measures might seem protectionist, because if you look at who are the countries that are producing sunflower oil, rapeseed oil as substitute biofuels, then those are predominantly EU countries. And then who are the countries that produce palm oil? Then it's Malaysia and Indonesia. So of course, they say that there is a bit of foul play here. Now, the way this last delegated regulation adopted by the Commission is framed is that basically at the end it has an annex, and then it has the various types of oils. So then it says, okay, sunflower oil, only 1% comes from territories which were previously forested or wetlands, which they tend to have a high, they capture carbon more than, for example, other places. So this will get this coefficient. And then if it's rapeseed oil, I think it's 8%. And then for palm oil, it's like 45% of palm oil comes from previously deforested lands. So they're pretty much, the EU's, this is already in the legislation. The EU's opinion is that these are not comparable because you don't have the same production methods. Why? Because for these products, predominantly that we produce, there's a very high percentage of them which come from these type of lands, while in the case of palm oil production, it's almost half of them that come from deforested lands. So who would be successful at the WTO level? And that's a very good question, because if you were to take the criteria for like products under WTO law, would all the criteria be met here? The end usage, you could argue both of them are, biofuel, but the production methods are different. The characteristics are different as well because palm oil tends to have a way higher yield. It also has a longer shelf life if, for example, you want to use it in the culinary sphere. So in my personal opinion is that because of these very differing production methods, I would not necessarily treat them as like products. So that's my personal opinion. I think it's simply, if we look at, and if these coefficients that are used by the EU are correct, then it's hard to argue that, at least at the production level, they have the same impact or not on the environment. But there might also be this argument, of course, that they have different product characteristics. Palm oil is also a lot more versatile. In this case, I would also, focus a bit more on what type of market are you using it? Are we only concentrating on the biofuel market? Are we concentrating on the bigger market or not? When it comes to the sort of, let's call it a framework agreement with China, right? Because it doesn't have much in it. It's sort of, this is where the second leg of the CCP comes in very strongly, and that's, or the third leg, the European Parliament's role. So the European Parliament, they came out quite vocally against it. So there is, of course, a chance that if this agreement were to move forward, if there are no credible commitments, for example, on the side of China, and then the question is based on what exactly, would it be human rights or other issues, then in that case, the European Parliament will simply not give its consent to the agreement. So this is where I'm also a bit torn, right? Because you do have a new actor and it's a very important actor and it complicates the process and it makes trade policy more difficult. But on the other hand, we've seen some beneficial results. For example, when it came to data privacy and how easily data could be transferred to the United States or not. So in that case, the European Parliament had a decisive role of changing a bit the ongoing policy. In this case, I would bet probably my money on not a lot, but only a bit. But I would bet on the European Parliament if the negotiations are going forward with Indonesia, then they will be very adamant to have sustainable development chapters, either which have stronger legal enforceability, and we see a move towards that. That some of the new chapters, they tend to be written in more legalistic language. But I also wouldn't, because of the specific context, I wouldn't be surprised if there would be a specific provision addressing palm oil, addressing deforestation. So you wouldn't just have a more general sustainable development chapter with some more legally enforceable mechanisms attached to it, but you might, on the insistences of the Parliament, have something very clear on deforestation or palm oil or both.
No, it's really a great topic, and that's a very good answer. It always kind of boggles my mind as well, in that the EU Parliament is actually kept abreast of the negotiations throughout, and then leaves it till the end to object instead of doing so during the negotiations. But
can I just add something? So this is this is something interesting with the European Parliament. I've written in the context of investment law I think 5 years ago, a paper on this. And, the way EU integration unfolds is always have the Commission and the Council close together doing things. And then always with every treaty amendment, give something to the Parliament, let them be happy as well. And in this case, the Parliament only has the veto right. So it can't technically, it's only the Council that approves the negotiating mandate, and it gives the various negotiating guidelines to the Commission, and then the Commission goes on and negotiates. But there are two important factors here. So one is express Article 218(10) TFEU, which says that the European Parliament shall be informed throughout the process of negotiation. So they are always aware of it. But there's also a lot of indirect pressure. So there will be often the Parliament or members of whatever committee from the Parliament, they will meet with people from the Commission, and they will send very strong signals. They will say, look, if this is not in the agreement, we might just be using the veto power. So They can use it at the end as well, but there's a lot of this sort of behind the scenes type of pressures from the EP we don't necessarily see.
Yeah, absolutely, absolutely. Two more, and one here is, I guess the question is essentially, given that this industry, the importance, I guess, to Indonesia, to Malaysia, that is creating income. I mean, there is obviously quite a balance. This is from our friend Shmu Yera Shlami from Israel. You know, I guess, I think the question's really trying to hit on, is this really an environmental measure, or is it just protectionism described hidden as an environmental measure here? And I'll just kind of flesh that out a bit and add, you know, I guess, isn't it easy to really try to hide protectionist intent? And you did hit on the fact that the alternative producers are generally going to be European. So that's one question. And then a second question actually is just, I'm going to add my question. I'm just wondering why investment is a value at all. I get that you've put it on the low priority, but it seems to me it's really on the same level of trade. It's almost hand in hand with trade. I get, of course, environment and human rights. These are clear values, but investment is just kind of something that occurs, and of course there are values hidden within investment. But I'm wondering why, in fact, you've listed it as a value at all. That would, if I was the reviewer of that paper, I would have said that.
And that's exactly one of the comments I got. So yesterday at 11 p.m. I had one of these ideas of how exactly to handle that question. So let's start with that question. One of the reasons I wouldn't necessarily call it a value. So the idea is, like, if you look at, let's say, articles 2, 3, 21 TEU, on the one hand, they're values, but they're also objectives. So 2, 3, they're more couched in the wording of values, but then 21 sort of takes it further and then puts it out as objective. So it says the EU shall safeguard democracy, or the EU will help develop environmental protection, or the EU shall foster sustainable development, right? So then it sort of gives, it fleshes it out and it says, well, this is an objective. Now, of course, investment is not included in these. So in a way, that's why I put it down at the letter, because it's clearly not within these values and objectives, but it's part of the CCP, right? So it's clearly part of the CCP. And as you said, yes, it's linked to trade, but it is also separate from trade. It's separate from trade agreements. You know, I've done work with a former colleague on, for example, how prevalent is it to include investment chapters into PTAs? It really depends on which part of the globe you're on. And I consider the two, you know, at the end of the day, still two very separate things. Separate epistemic communities, separate standards, separate dispute settlement procedures. So I would say this is something other than trade, and it is being included now in the common commercial policy, and it is being included in the trade negotiations. So it's something. Is it a value? What I did to satisfy the reviewer, now I said it's an objective. So I would say a non-trade objective. And I hope the reviewer will be fine with that. And it's also because it really caused a lot of headache. So this, with the current situation with Indonesia and Malaysia, is still okay. With investment law, I mean, if you wanted to write about investment law the last 10 years, you had every year something new coming up, a new court case, a new court opinion. So it's a really rich tapestry, and this is why sometimes I would say states should be very cautious when they amend something, the words they use, because I mean, the story is too long to say, but somehow the FDI, the three words, ended up in Article 207. It was technically the Commission who sort of pushed it in last minute. Member states didn't see it. They adopted the Lisbon Treaty. Then the Commission comes to them and says, hey, by the way, now we're concluding BITs, the EU. Then the member states woke up like, wait, what's happening? And you can see that three tiny words have caused a lot of mess. So that's why, in a way, I'm thinking, is this expansion of the scope of the CCP and including all these non-trade values in the end, will it just make it so tangled, so difficult to maneuver that the EU will lose ground as a normative power, exactly because either it will lose credibility, it will frustrate other contracting parties, and because it will take, a decade just to get the negotiations done sometimes. And then to the first question, right? Because that harkens back a bit to the previous discussion as well. Would it be protectionism? I mean, that really is the case, right? And that really is. We'll see if how the WTO panels will decide here. I would say there is a bit of hidden protectionism. I mean, this is really going the conspiratorial way, but the EU is the second biggest lobby hub of of the world after Washington. So it wouldn't surprise me that there are certain interest groups within the EU who produce biofuel, who would exert pressure when these legislative instruments were adopted. But that's taking the more conspiratorial way. I personally have an issue with biofuel as such. It is definitely spreading in the EU. As someone who's Hungarian from Romania, I've seen in the last decade where you have very big companies coming in, they put together hundreds of small plots of land, and then it's just yellow as far as you can see. And then you basically use land meant to produce food, to produce fuel. So I do have an issue with that. And then you can really argue a bit of, well, weren't these lands at one point also forested in Europe? Yes, they were. They were at one point forested, and now they're agricultural land. And now all of a sudden we say that it doesn't have a big environmental impact, but in a way it does have a big environmental impact. So I wouldn't necessarily deny that there is a level of protectionism involved. And you could even have something called, like almost like a monstrous coalition, right? Because in this case, not only would you have an environmentally friendly NGO supporting the same cause, save the rainforest, but you would also have industry saying, yes, save the rainforest, like we don't want this palm oil and so on. And then as a legislator, it's very easy to push that through because then you don't really have opposition to it, right? You have the environmentalists on one side and the industry on the other side, and everyone's very, very happy about it. But some of the literature I read now, and this was more from economists who were trying to look at the effects these EU measures are having on Indonesia and Malaysia. Apparently for exports, they don't really have much effect anymore because some of the exports are being redirected towards China and India. So in 2017, I think the EU was on the second place when it came to palm oil exports for Indonesia. Now it's on the third place, China and India taking the pole position in this case. So we have trade diversion towards these two countries. And then on the other hand, you also have the issue of, and this is what I mentioned now in the revised version of the paper, of the EU in itself in these non-trade values has to pursue competing values. On the one hand, you want to eradicate poverty, but you also want to ensure environmental protection and sustainable development. And often the three will have to be somehow compromised, right? You will have to give a bit on this side and then you have to help a bit the other side, because there is the argument that 2.5 million people's livelihood depend on it. It is quite a financially good crop. It has a very high yield. It grows fast. It provides financial independence for many smallholders as well. So yes, I think that's why I'm more compromissory in my nature. I would say in this case, if you adopt this type of legislation and you don't want it to affect your trading partners, then maybe it's better get off the high horse a bit, go there, understand what the situation is, what are their concerns, and how can there be a mutually agreeable solution on both sides.
Yeah, well, I hope they heed your advice there. I'm not too hopeful at this time. There's also a great story behind that usurpation of power and control over investment, I guess, but we'll have to wait for another day to hear that one due to our time constraints. I'm going to turn it over. Our colleague Fernando Dos Simos has a question as well, and I think he's going to ask it via audio.
Yes, thank you. Thank you, Brian. Thank you, Szilárd, for this excellent presentation. Very good to see you. You mentioned that the common commercial policy has become inflated in that it pursues too many objectives simultaneously. I agree with some of your criticism. In my opinion, maybe the European Union is too invested in taking the moral ground in trade negotiations, which make those negotiations extremely confusing and, as you just mentioned, even contradictory. Do you think this is just to please domestic audiences, which are often very critical of giving the Commission too much power? And in that regard, do you believe that the impact assessment studies that have been promoted as a way to further this holistic approach are just window dressing? And the second question, which is related to this one, you also mentioned the role of the European Parliament. I agree that it makes negotiations more difficult and also highly politically charged. It is also true that it makes them a bit more legitimate and thereby probably easier to accept internally. Just think about what happened with the TTIP negotiations that became a political hot topic, especially in Germany. So I would like you to discuss these issues that have to do more with the relationship between trade and politics, especially for the benefit of those who, unlike us, do not have a European background.
Thank you very much, Fernando. So I will probably be stretching a bit, what I would say is maybe what is academic and what is probably hearsay. And over the years, having spoken to people and gone to stakeholder meetings, and at one point I was involved in a project where my counterparty actually had interviews with certain high-level politicians, but this was more about investment law. So I would say you have several points here. Does the EU take the high moral ground? Yes, I think it does, right? So this was already pointed out by Horn and Mavroidis in 2010 that compared even to the US PTAs, EU PTAs, they were inflated, and they called it legal inflation because a lot of these new standards that were included were more for window dressing purposes. They were not legally enforceable, but we do see a shift in sustainable development chapters. So sustainable development chapters lately seem to have stronger enforcement mechanisms. That's not really my area of expertise, but there's a very good article on it. I think it either, and I cite it in the paper, it was either 2020 or 2021, someone who looks at the legal enforceability of EU sustainable development chapters. And why would the EU do this? Now, that's the thing. What is the EU, right? It's always that question of, it really depends on the angle you look at it from, because often the EU is just conflated with the Commission, because the Commission tends to be more of the image of the EU, and then you see, Ursula von der Leyen, and before you saw, Mr. Luxembourg, who used to like a bit to drink too much. I'm sorry, but I didn't have the highest opinion of the previous Commission president. And what would so you sort of like a lot of people would conflate what the Commission wants with what the EU wants. But then, of course, you have the two other important actors, the EP, which technically is democratically elected. And as you say, it gives more democratic legitimacy to the process. And it is there to represent sort of the people's concerns, also the industry, depending on who's behind whom. But also you have the Council, right? And then at the end of the day, when it comes to trade negotiations, the final stamp does come from the Council. And that's where the member states come in. And the member states, depending on their own interests, either can act as a united group or not. So we've seen it, for example, that when it came to opinion 215 on how to delimit competences, when it came to investment and trade, then the member states were almost a unified bloc, right? Because they didn't want to give up competences to the EU. When it came to intra-EU bilateral investment treaties, the member states were basically split on the exporting, importing side. Capital exporters wanted one thing, capital importers wanted one thing as well. So you don't really, often you don't have a unified voice. You have, all these institutions, and everyone has to please some form of a constituency. So probably in Austria, in Austria, they had quite a lot of pushback from civil society. Therefore, Austria doesn't want to go further with EU Mercosur. In Germany, you had a lot of pushback once again from civil society against TTIP. So there are those concerns that, and in Wallonia as well, that start out at the bottom ground, go up, and whether the politician believes in it or not, doesn't really matter. They're trying to convey the message. In some cases, it improves the process. In some cases, it makes it too complex. I know that you've written on impact assessment, so you're probably way better positioned to talk about impact assessments. Once again, the cynical view on impact assessments is that often it is window dressing, and you have a couple of, very big consultancy firms who get fairly lucrative contracts from the Commission to provide these impact assessments on many grounds. However, I think impact assessments are important, at least internally, because they raise various issues. They can politicize some of the issues. But then again, it's also a question of, do these issues end up going up to the EU level machinery? And that really depends on, for example, do you have a concerted action from NGOs? So in the case of TTIP, there was a lot of anti-American sentiment, and there were a lot of often not the best type of characterization of ISDS. And but you really had concerted action on the NGO level, and then they could really politicize it, and then that became an issue. But and probably that will be the case also with palm oil if they get this traction. So I think impact assessments can be useful. Because they highlight that there might be other issues as well that maybe the negotiators do not focus on. And in a way, yes, I would say that the EP now, the role of the EP gives it more legitimacy to the process, but it also just, it brings in another actor into the process. It complicates things. And then the question is, as you said, if you look at it from the external perspective, sometimes EU lawyers and EU experts, they tend to be too focused on what they think the EU does, as opposed to how other people perceive the EU. And there is rising literature, for example, on that questions this idea that the EU truly is a normative power. Does it really change another country's behavior internally, or the other country simply pays lip service to it because maybe it will get some economic benefit from it? And I would also argue that there has to be more coordination with foreign policies. So I would say that one of the biggest blunders was the agreement with Ukraine. So the association agreement with Ukraine, because I know this for sure, that they didn't have enough experts on Russia. They didn't even have people who would speak Russian. They didn't understand the threat, or at least the perceived threat on the Russian side. And that caused then the events in the Ukraine. So yes, I would say more consistency, and yeah, I think that's it, because I tend to talk a bit too much.
Well, it is a perfect timing. In fact, it's 6:15 now, so it is time for us to end. And I think that's a brilliant point to end on. I found your talk fascinating from start to finish, and agree with a number of points you've made. I'm looking forward sometime in the future to meeting and discussing these further. From our perspective, I'm not even sure if we'll open up by 2022, but hopefully in 2023 we'll be able to meet. So thanks again for really taking the time to talk with us today. So on behalf of the Center and CUHK Law, we are all very grateful, and hopefully you enjoyed the experience as well.
Thank you very much, Brian, Fernando, and everyone for listening. And we will start teaching in person as well. However, whether I will have fuel to drive to Birmingham to teach, that's a different question. So, you know, if you think Brexit is going well, it's not. It's really not going well.
Good.
Okay, so thank you very much, everyone.
Good luck with that. That's perhaps a topic for a future seminar. Is Brexit going well? And all right, with that, have a safe drive and a good teaching session. And thanks again. And thank you everyone for listening and tuning in today.
Thank you very much.
Goodbye.